We are discussing that breaking news item out of the Supreme Court. I brought out C.C. Heil and senior counsel here at the ACLJ to really give you guys a big understanding of what this ruling means, because you may see a 9-0 loss in the terms of the allowance of the abortion pill to remain on the market. But when we broke it down a little bit, that's not necessarily what it says. And there's actually some, as Will pointed out, you don't want to say a silver lining in this, but there is a silver lining for future cases in this decision.
Yeah. And, it is obviously you see this ruling and you think, like you just said, oh, gosh, this is, a defeat. But it's a technical legal thing. And when you lose on standing, and this is just kind of a general thing, you have to have an injury. You have to be injured, personally injured, to be able to bring a lawsuit. And here, the court, I think, rightfully acknowledges that they have no injury in fact. They're, saying that it's downstream, and they're not the doctors that are prescribing Mifepristone. They're not a pregnant woman who's possibly taken Mifepristone and had terrible consequences happen because of these, released kind of and relaxed restrictions. And I don't know if you went over this, but, in 2000, that's when Mifepristone was first prescribed. And then, and at that time, it could only be prescribed up to 7 weeks of a pregnancy. A doctor must have prescribed it. It had to be prescribed by a doctor, and you had to have 3 in-person visits. In 2016, the FDA then starts relaxing these regulations and says, well, now you can use it up to 10 weeks. And guess what? A doctor doesn't have to prescribe it. It's just a healthcare practitioner that can prescribe it. And you don't have to have 3 in-person visits. You have to have 1 in-person visit.
Right.
And then we go to 2021, and they're like, you know what?
Loosening.
You don't have to have any in-person visits, and you don't. So I can see that there is a client, a plaintiff in this case that has been harmed by what the FDA has done, because there is an argument that these are not legal changes that they've done, but this entity was not the one to bring it.
Yeah, it was the wrong case to go to it. And obviously, we're supportive, and there's other legal groups who bring this sort of case forward, and obviously, if it's to do with life, we want to get involved. The ACLJ wants to get involved. Ever has to do with life, and we did get involved where we thought was appropriate, but it didn't even quite get there. It does make you wonder how you get to the Supreme Court knowing that this is kind of what the result is going to be. Knowing that result is going to be, like you said, there is no standing. 9-0. Potentially, this was the court that overturned Roe, the most pro-life court, maybe on record. And now you make some sort of blunders in some ways. And it's really disappointing to me as someone who has been a pro-life activist my entire life to see these kind of situations go. And I think that's why you got to be very careful. And look, I don't point fingers at any other organizations, legal organizations, Christian legal organizations that do good work. I think there's some other great entities that do it. But we are very selective at the ACLJ on what we take, how we take it, and how we proceed forward.
Yeah.
And sometimes you lose, sure. But sometimes you don't lose 9-0 over standing because you can't even get to the meat of the issue.
Right. And there are absolutely legal concerns. And the court even gives a nod to that, that there are legitimate legal concerns about Mifepristone and how the FDA has approved it and how they have relaxed, their restrictions. And so there is a legal argument. And I don't, discredit anybody for trying it, but to just say, okay, standing is an issue. And the Fifth Circuit, they said they had standing. So this was an issue where a lower court had decided, yes, they're standing. But trying to find that really good plaintiff so that you don't even have to get into these arguments that are kind of the technical arguments.
The legal, legal side, but the legal, technical, law school, analytic side, not to do with the people or the case or the actual issue that's at hand.
That's right. Because again, I do think there is a claim to be made that what the FDA has done is not right and can be legally attacked. You just have to have the right plaintiff to bring that case.
Now, we told people there is a little bit of a silver lining here, and this comes in the form of the concurrence by Justice Thomas. Clarence Thomas is known as arguably the most conservative member of the Supreme Court. He's the left's favorite person to attack because he is so conservative.
Alito now. I feel
like that's right. Now, Alito, he's taking some of Clarence Thomas's love there. Yeah. But he wrote a concurrence, and he said he joins the court in full on their rationale of standing. And so when you're hearing this from Clarence Thomas, you have to set aside maybe what you wanted to happen and think, I trust his legal jurisprudence.
Yes,
I trust his rationale. He's one of the most logical members of the court and typically delivers for conservative victories on the court. But this is actually a legal analyst on MSNBC, broke down the concurrence. So I want to play this. It's Bite 20, and then we're going to talk with Cece about that little bit of silver lining of how it could actually help fight back against people like Planned Parenthood in some of the lawsuits they bring against pro-life folks after we play this bite.
What no one has talked about in this 38-page opinion is that it was unanimous, but Justice Clarence Thomas, one of the most stalwart objectors to abortion on the court, filed a separate concurrence. And in that separate concurrence, he railed against the court's third-party standing doctrine. And he said that if this particular organization lacks standing, then other organizations, including abortion providers, abortion clinics who frequently bring lawsuits challenging abortion laws on behalf of their patients, also lack standing. So he is laying the seeds for this to eliminate standing for the traditional panoply of providers who would bring these cases on behalf of their plaintiffs.
That's absolutely correct. And even when, I realized that this opinion had come out, that's truthfully where my mind went.
Explain that. Let's break that down for me, because there were sound issues in there.
Right.
So make sure it's clear.
So just as abortionists lack standing to assert the rights of their clients, doctors who oppose abortion cannot vicariously assert the rights of their patients. And why this is so important is because every time we have a case or pro-life law that's passed, it's usually Planned Parenthood. It's usually the abortionists that come and bring the cases on behalf of their patients. And so this is an opportunity where Justice Thomas was able to say, abortionist cannot do that. We're ruling in this case that this, pro-life alliance can't do it. But let me explain to you, that also means unequivocally, exactly, that these abortionists cannot bring those cases. So I kind of figured that's what I would read somewhere in the opinion of, he is absolutely saying in the future, we're going to throw out these cases on standing when the pro-abortionists bring them.
If you have a question about this, 'cause I know it gets very technical, because you may be just seeing the headlines. That's why I wanted to bring in Cece. It's why I want to bring in our legal expert, so you can go a little bit beyond the headline, because the headline is big loss. It's big loss. The abortion pill allowed 9-0. That can seem like a major defeat, but always there's usually something in the Supreme Court opinions that can be taken as a win in some ways.